Hey everybody, John the Other here, obviously. And if you've been watching my channel, you've probably seen me recently do a video about the Liberals' new proposed bill, which has now passed its second reading and is going to committee, called Bill C-51. And this is a bill being talked about as if it is an updating and modernization of the criminal code. And it's kind of a mini omnibus. It's got a whole bunch of stuff in it. Getting rid of witchcraft, they're going to legalize dueling again, but they're also going to add a provision to section 276 of the criminal code, which is the rape shield laws, where you cannot introduce a complainant's sexual history into a court case about a sexual assault on the grounds that if they are sexually promiscuous, they are more likely to have consented, or if they are sexually promiscuous, they are less credible, like less reliable as a witness. And they call these things the twin myths. Now, the thing being added by this new law is that if you have messages, text messages, emails, written notes, video recordings, audio recordings, specifically addressing the sexual incident under question that this whole legal trial is about, a sexual assault, that also is to be excluded from evidence on the defense side unless and until you make an application to have it included, in which you must disclose your evidence. And that's the problem. Now, I think text messages and voice messages and emails and so on, specifically about the sexual event in question, either made those messages sent before or after, are extremely relevant to a person's defense if they're charged with a sexual assault. And not only are they relevant, you don't want to transmit to the prosecution in advance what text messages or voicemails or handwritten notes you have, because you want to be able to catch the prosecution lying. You want to catch them in their lie and say, well, no, I have the evidence, and here's the message I got, or the emails that we sent, which show that the story being told is false because she actually sent me this email or whatever. Now, C-51 will exclude that, or if it doesn't exclude it, will require you to disclose it to the prosecution. That's a big, big, big change. It means you have to disclose your defense to the prosecution. Well, you really don't have full answer in defense anymore. That was my position up until a couple of hours ago. However, a lawyer, a former Crown prosecutor, I believe, has written an article for the Toronto Sun in which this prosecutor, whose name I don't know yet, but I'll know it by the time I'm finished editing this video, this prosecutor assures us that this is not the case, and Bill C-51 is nothing except a modernization of the criminal code. Nothing to worry about, nothing to see here, folks. Move along. Let me read you a little passage. Some hysterical defense lawyers have had the ear of post-media columnists Christy Blatchford and Barbara Kay, who have been channeling their supposed worst nightmares about Bill C-51, which finished second reading in Parliament and is now headed to the Standing Committee on Justice and Human Rights. Hysterical defense lawyers. Not defense lawyers. Not concerned. No, hysterical. That's a little bit inflammatory, don't you think? Even more so than I usually am on my YouTube channel here. And it's all the fault of those, quote, radical feminists who are on a mission to convict the innocent. Blatchford even writes that the bill has had scant attention, probably because it touches upon the accepted and sacred wisdom that women just can't get a break in the criminal courts. I beg to differ, the author says. It's received scant attention because it's merely the case of legislation being updated with the times, particularly technology to modernize the already validated but dated rape shield law. The law deals with the twin myths. First, that past sexual experience can't be used to show it made complainants more likely to consent to sex, and second, that their past sexual activity makes them more or less worthy of belief. She continues, and here we get into some really nice juicy lies. When rape shield law was introduced, defense lawyers were also howling about how shocked they were at this new law. Heresy! Exclamation mark. The froth should be a bit of a giveaway that there's not much substance to the claims being made in this article. Now, the author continues and writes The Supreme Court of Canada upheld the constitutionality of that law in a case called Derrick in 2000. And she also says, I was the assistant Crown attorney who prosecuted the case in the early 1990s, which took over a year to conduct due to a slew of schmaltzy and baseless defense motions. Schmaltzy and baseless defense motions. Well, if they were schmaltzy and baseless, how did they get to the Supreme Court for appeal? Clearly, the defense motions were not schmaltzy and baseless. They had merit, because not every case gets to the Supreme Court. Lots are slapped down, say, no, we're not going to consider this. If they get to the Supreme Court, the motions of a defense will have merit, even if later on they're struck down at the Supreme Court level. But we're also being lied to about Derrick in 2000. Prior to Derrick, in the 90s, there was a case called C-51, which was another Supreme Court decision in which the twin myths, the myth that a woman can, if she is sexually promiscuous, you impute consent more likely, or that if she's sexually promiscuous, her testimony is less valuable, that she's less reliable. Those are the two twin myths which are excluded and were excluded in C-51 before Derrick. But in C-51 they found that they had excluded too much because they had barred people from bringing in evidence that was relevant, and C-51 corrected that, because you can only exclude evidence based on C-51 if it offends one of the two twin myths, namely that a person's testimony is to be considered less valuable because of their sexual history, or that you are imputing consent because of a history of consent or a history of sexually promiscuous behavior. Don't you hate being lied to, especially by people trying to change the law? Skipping on a couple of paragraphs, the author says, text messages, emails, and video recordings were in their infancy, even if they existed in 1992-93, so they weren't included in the language of the criminal code. Now they would be. Everything else stays the same. Well, isn't that nice? If text messages existed back in 1992 and 93, they'd be included in the 276 provisions and excluded from evidence. Well, let's actually read what's being added in Bill C-51 and see if this is true. For the purpose of this section, sexual activity includes any communication made for a sexual purpose or whose intent is of a sexual nature. That's what's going to be added as excluded under the existing rape shield laws. Any communication. Well, it doesn't say emails. The word email is nowhere in there. Text message. It doesn't say text message. The word text message is nowhere in that language. In fact, that language could include a handwritten note, or it could include a video recording made on a 1990s era VHS video recording device. It could have an audio recording made on a reel-to-reel recorder. So, again, we're being lied to by the author of this article. We're not talking about email specifically or text messages specifically. We're talking about any durable communication in which consent could be recorded. This provision being added in Bill C-51 is to exclude any record of consent should you be forward-thinking enough to make such a record. No, this is not just the updating of the law to reflect the modern advent of text messaging and emails. It's specifically to exclude evidence or put that evidence in front of the prosecution so that you can't surprise them in their lies. We're being lied to. And I don't know about you, but I really, really hate being lied to, especially by people lying to me who want to change the law. Now, the final provision not being mentioned by this former Crown prosecutor who published this article without publishing their name, I wonder why, also says that the law will, Bill C-51, will provide that a complainant has a right to legal representation in rape shield proceedings. So as a person in the defensive position, a person falsely accused, you're not just going up against the Crown prosecution and their nearly unlimited power with your little private financing of whatever lawyer you can afford. You're also going up against a lawyer provided by the government to your accuser, So it's 2 against 1. 2 gigantic government-funded lawyers against you and your little whatever lawyer you can afford. But, you know, according to the article, the author says, but no! It's actually simply a bit of spring cleaning and making sure the criminal code is with the times. If the bill becomes law, expect the same legal challenges as in Derac. Also expect the Supreme Court of Canada to uphold it. Now, go back to what you were doing, because there's nothing to see here. Look away. You're not being lied to, or misled, or swindled. No. Just don't worry your pretty little heads about it. Thanks very much for watching. And as always, have a lovely day. And I hope that you, like me, hate being lied to.